I'm happy to be here and to offer my expertise on this very important topic on African integration, which, as Honorable Yusuf has stated, it's culminating from all the way during colonialism to pre-colonial time, to all the efforts by African countries to use trade as a tool to unite. And therefore, because he covered a lot of what I was supposed to cover in relation to the historical foundation and negotiation of the AfCFTA, and that's why I would combine the two modules, and I would like to make it as practical as possible, because the title of this training is about how we can prepare our legal practitioners, trade experts, and judges on how to implement the AfCFTA competition protocol. So I'll focus mainly on some of the controversial issues that arose during the negotiation process, and then we can see how we can provide the predictability of enforcing the AfCFTA agreement. So because it's gonna be very practical, I have some fundamental questions, and I'm so excited that we have judges of commerce and ESC here, and they're the ones that deal with some of these legal tests of determining some of the questions that Honorable Yusuf discussed. So if there's anyone who would like to answer these questions, like why are you here? What do you know about the AfCFTA? Which knowledge do you have? Do you think it was very important to establish the AfCFTA after all the regional integration efforts we've had, especially with the existing regional economic community? And why is understanding the AfCFTA agreement important to you? Anyone wants to start?
Thank you so much. I still remain Abe Mubanjizi from Uganda. To respond to fundamental question one, I am here because I purpose to look more into what the AfCFTA presents in respect of the region as far as the ESC and the African bloc is concerned. And what I know about AfCFTA, I may skip that, but part three, why I think it was important to establish the African Continental Free Trade Area is a matter of the regional integration and trade practices. Many nations in Africa have a lot of trade barriers, especially that affect how countries relate. We can look at some of the recent ones, being the Uganda-Rwanda standoff in respect of the border. And that was not necessarily a matter of trade, but from the beginning it was a political matter, which ended up affecting trade. We can also look at the standoff between Juba and Uganda, and most of instances where the Ugandan border accessibility is blocked on both sides, and you find trucks are precluded from moving on. So the AfCFTA coming in is to break these barriers, break the silos that exist amidst politics, amidst what key aspects need to be considered, and we overlook the politics and we deal together in respect of the African continental bloc as one trade area, as one trade ground. And then on aspect number 4, why understanding AfCFTA is important to me. As an individual, I have purpose to look at why regional integration on one hand is key, and two, why it is important to have trade as a key unifying factor. Now, the African Continental Free Trade Area brings together different key aspects of trade. In my experience, for example, I am a prospective student of the University of Turin, Masters in Intellectual Property. I am looking at bringing together ideas, bringing together components of trade, bringing together the trade itself, and understanding it to make sure that as a policymaker, as a consultant, as a legal professional, when I am dealing with aspects of advice, when I'm dealing at documentation, policy development, I am alive to what I am doing. And with my experience with some of the documents in the East African community and the African peer review mechanism, I noticed that there are some fundamental contradictions, and when you come to, for example, regional meetings in respect of these documents, you will find that some sectoral committees are saying this, which contravenes what is being brought on board. So in my view, it is so important that understanding AfCFTA brings the end to these barriers, to these contradictions, and it is a move towards harmonized integration, harmonized policies. Thank you so much.
Thank you so much for that summary. And that's why we say if we are going to have an effective training, we must first understand why we are here and why this topic is very important to all of us. So from the onset, as Honorable Yusuf said, the issue of integrated market has its origin in the European Union. And therefore, in most cases, we've had the European Union, not only in Africa, but also in Latin America, pushing the agenda of having an integrated markets for political reasons and economic reasons. So I don't want to really go into details here because Dr. Kofi will be dealing with this, but this is exactly how the architecture of the AfCFTA agreement looks like. So we have 8 protocols. In the first round of negotiations, we had the protocol on trade in goods, the protocol on trade in services, and Regis is here to talk about it, the protocol on rules and procedures on the settlement of disputes, competition policy, intellectual property, investment, women and youth in trade, and also digital trade, which is extremely important to also understand the issues of digital trade and all the annexes that pertain the implementation of the AfCFTA agreement. So for legal practitioners, this topic is very important because we are creating another level of supranational law. Supranational law is legally binding regulation that go beyond national states, in which national states are required to cede the regulatory authority to that institution, and that institution makes binding decisions that member states have to adhere to. But in most cases, member states might be unwilling to cede their sovereignty, and that is why we now have the issues of political challenges that adhere to this. And all of us understand why the issue of domestication of African treaties has been a big challenge for the African integration, which really negatively affects our ability to implement the treaties that we have. And the judges that are here have handled a lot of these cases, especially those that have arose from Mauritius in regards to a lot of issues pertaining the implementation of the COMESA Treaty. So we are shifting from national regional law with the existence of the COMESA, EAC, SADC, and all this regional economic community, and we are creating a third level regulatory regime. And therefore, it's not just a matter of national regulatory authorities, it's also a matter of how regional economic communities will be able to cede the authority in areas that they are already established, especially in competition policy and intellectual property, and how also the AfCFTA is creating a very sophisticated dispute settlement mechanism, and as Honorable Yusuf argued earlier, most of African countries have understood regional integration efforts in Africa as informal, voluntary, a form of cooperation, and therefore they are more willing to cooperate on issues that are pertaining to regional integration. And most important, there's now liberalization of services. So as lawyers, you're going to have clients beyond the regional economic community, and therefore you must understand what is going on the continent and what is going on outside the continent, because it's not the first thing that is happening at the global level. Therefore, from the European Union to Latin America, and even in Asia, we are going to learn a lot on how to implement these issues. So on the question of the historical foundation, and that's very important, what Honorable Yusuf talked about, we must first understand where we're coming from the days of Nkrumah, and from the days of Nkrumah and all the leaders that sought to ensure that we're going to have an Africa that is self-reliant, that's not economically dependent, that goes beyond the markets that the colonizers had created, because Africa had remained a place whereby the colonies came here to get resources and raw materials, and therefore we were more of exporters than importers. And therefore, we are now trying to diversify our markets in a way that we can also contribute to other products. So I'll just pass through because Yusuf did all this. So initially, from the early Pan-African economic thought, trade integration was seen as a route to political unity, but at that time, what was very important to African, especially the apartheid regime in South Africa that we were trying to fight over, was to have first to ensure that African countries are no longer colonized, they have their independence, and therefore, and then use trade as a route to political unit. And now the establishment of the Organization of African Unit, focus on decolonization, sovereignty, and promoting continental unit. There was a limited economic integration, but if you read the work of Nkrumah, he really pushed for the issue of using economic cooperation in liberalizing African market. And then, of course, the Lagos Plan of Action, which focused more on economic self-reliance, industrialization, and reducing dependency on West economies, and also ensuring economic diversification. So the turning point started during the Abuja Treaty, whereby it's at this point that we start seeing African countries really creating an established way towards continental economic integration, and emphasizing that regional economic communities can be used as building blocks to ensure that African markets integrate. And I think one of the reasons why we were using regional economic communities, because especially in the ES country, it's easy for neighboring countries to trade with each other because of the logistics that are involved, ECOWAS countries trading with each other and so on. So it was thought that if we start with the regional economic communities, now we can move towards a continental market. Then we see the shift in 2002 under the African Union, where under the new Partnership for Africa Development, the issue of trade is prioritized in addition to peace and security. And then in 2013, the Agenda 2060, which seeks to boost inter-African trade, which we've been reminded that by the time it's 2063, we'll be so old. Grandmothers, some of us will not be there, but we hope that this will be achieved during that time. So from this regional integration process, there are a lot of challenges that we learned that the AfCFTA should be able to also learn, and as legal practitioners should also be able to identify them. Because as a practitioner, especially in cases that I've handled with competition policy, for those who know the COMESA Competition Commission, immediately the COMESA Competition Commission started analyzing and assessing mergers in 2013. The competition authorities and some of the COMESA member states contested the idea of whether COMESA had jurisdiction over mergers that were emanating from domestic markets, on the argument that they had not domesticated the COMESA Competition Treaty, they had not domesticated the COMESA Competition Regulation of 2004. And you realize that in the work that I've done in one of my papers on why and how national competition authorities support supranational regional economic communities, the issue of political commitment, especially towards domestication of COMESA Treaty, has been slow. For example, Zambia, which hosts the COMESA Secretariat, is yet to domesticate the COMESA Treaty. Malawi, which hosts the COMESA Competition Commission, is yet to do that. So you can imagine countries that are hosting institutions, if they have not been able to do this, it becomes really crazy. And then I like what you talked about. When we were talking about African issue, we should also be able to understand that African markets are very different. The informal market is what is driving the African economy. So how can we support the SMEs to be able to go beyond the non-trade and the non-tariff barriers at our borders, to be able to understand and enable them to be able to enter these markets? Because the main reason why we are establishing this market is to enable our small businesses to enter into new markets, to create regional value chains that are able to compete not only on the continental level, but also on the international level. And it's not only about the internal problems, as you see when we are talking about the AfCFTA at that time, Kenya having the trade deal with the US, the economic partnerships that are going on, while we're saying, can we trade as a bloc? And that is why intra-African trade, intra and inter-trade in Africa is very low as compared to Asian countries, as compared to Latin American countries, and also in the European Union where they trade among each other. So all these issues are what the AfCFTA market is trying to address. And if they have not been addressed at the regional level, we are going to face the same challenges, not forgetting conflict and political instability. So that's a summary of everything because Honorable Yusuf had done all the detail. So let's look at the negotiation of the AfCFTA, moving towards a continental market. So in summary, it looks like this. In 2012, the decision is made in Addis Ababa that it's now time to make this a reality. The negotiations are launched in June 2015 in South Africa. And in 2018, a number of African countries ratified the agreement and the process kicks off. And in 2019, on 30 May, it eventually enters into force, and trading started in 2021 January under the guided initiative. So a number of countries, Ghana, Kenya, they have a partnership of trading in coffee and so on, if you've been following these key developments. So this is just a summary. I think I'll share the slides of all these, the negotiations, the rules of procedures that have been adopted at that point, and the signing of the AfCFTA agreement in 2018, the operationalization of the entry into force in 2019, and then the negotiation structure. The first one, negotiations, which focused on the protocol on trading goods, trading services, dispute settlement, and of course we also have the first two negotiations that are focused on the protocol on intellectual property, competition policy, which we'll discuss on Wednesday, and so on. But there's something that is really important, apart from just saying, oh, this happened, this happened, this happened. It's very important now to understand the most controversial issues that arose during the AfCFTA negotiations and how these issues are going to influence the implementation of the AfCFTA agreement. We go back to the political economy from the Monrovia, Casablanca groups that differed on way in which we were going to implement regional integration of the African Union. So in this case, of course, the historical integration efforts really came in, and the issue of African countries' willingness to cede sovereignty to the AfCFTA, and diverse economic interests, with Western Africa producing maybe different goods, Eastern Africa, Northern Africa, affected also with climate change and the environment in these areas, and also domestic political influences. You must understand that when it comes to international diplomacy, for those who have studied international relations, domestic interests play a critical role in determining how international agreements are made. And this was the case with Nigeria. So when Nigeria took time to sign the AfCFTA agreement, it was mainly because the Manufacturers Association of Nigeria had argued that there was no public consultation at the national level, and also they were afraid of opening up their market, and they argued that it was going to create a conducive environment for dumping of goods, and therefore they also wanted to protect their borders. So in this case, this is where now protectionism comes in, and industrial policies that we need to look into. So if you're advising the government on these issues, you have to really come out clearly and explain to them what is the benefits of being a member of the AfCFTA. Eritrea also took time to sign the AfCFTA agreement. So it's not like because we have benefits, we also have costs. And these costs just go beyond ceding sovereignty to issues related with finances. Tariffs is a major source of revenue for our African countries. In the case of competition law, merger filing fees is a big resource for competition authorities. So the willingness for our regulators, our member states, to cede their sovereignty is really important. And also when I was just looking at the Nigerian case, and you should be following Afronomics law, where we discuss most of these issues. It's an organization where we try to give African voice into international development and other issues that are pertaining trade. So in the Nigerian case, at that time, it was an election period with the former President Buhari, and therefore he had to balance between the domestic pressure from the manufacturing association and also from the labor organization. Unions also raised the issues pertaining whether there was public consultation on this issue, and balance this with what was required at the AfCFTA. So it's very important in this process that we make sure that we bring all the stakeholders on board. So market access and protection concerns, especially from countries that are more developed, are issues that are going to arise. And for countries that already have their regional value chains, like in the cement industry, Dangote, in the digital market, we are talking about Jumia, Kilimall, and so on. The ability to enter into this market and monopolize the market, engage in anti-competitive conduct is also one of the issues you need to really understand and talk about. So we've talked about the financial cost that most countries are likely to incur. This was also a major issue during the negotiation process. So how can we literally manage these issues, especially issues concerning with physical shock concerns? Honorable Yusuf has emphasized the issues overlapping regional economic communities, and we'll have practical cases when I'll be talking about competition law. So you look at this, it's like a spaghetti ball, and it's not just an African issue, it's also in Latin America. So we have countries with overlapping membership, with different laws, with supranational institution. ESC has its own binding law, ECOWAS, and so on. And the AfCFTA agreements identify that regional economic communities are going to be the building blocks. And the principle of ACES tries to ensure that those regional economic communities that already have some level of development should continue enforcing their laws in that. So how are we going to deal with this issue? For instance, during the negotiation of the AfCFTA competition protocol, you see we are having 3 levels of national competition authority, regional competition authority, and the AfCFTA competition authority, and issues that have a national dimension that just are within domestic markets, they fall under the ambit of the national competition authorities. And now regional competition authorities deal with regions that have a regional dimension, which is measured by is the conduct affecting more than 2 member states. And then at the continental level, how do we identify a continental dimension? Is it when the issue is affecting more than 2 regional economic communities? ESC and COMESA. These are very important issues because they undermine trade. They raise jurisdictional conflicts, there's no legal certainty, conflicting decisions from different institutions arise, and it just leads into confusion. And when there's confusion in the market, investors will not want to invest in those kind of markets. And therefore, if we are going to ensure that our national champions are able to benefit from this market, and also we are able to attract foreign investors, we must ensure that the continental institution that we are creating in intellectual property, in investment, in supporting women and youth, when do they invoke their jurisdiction? So the issue of non-tariff barriers, these are usually non-monetary. We've talked about licensing, he has mentioned the issue in Juba and so on. The trust in all the institutions that we are creating, this is also a very important issue. So like someone wants to move their products from Uganda to Tanzania, and the non-tariff barriers become a hindrance to trading. So we have to identify how to do this. Readiness, capacity constraints, and the implementation challenge. One of the reasons why the Abuja Treaty did not work is because we were depending so much on international aid. So this is what we are now doing to make sure we strengthen your understanding of these issues, because in practice, when there's a dispute, we move away from theory and we start understanding the key concepts. We start looking at the precedents. It's all about like the law says this, now we have to solve the problem. And that is exactly what you're doing. How do judges identify the legal test of the core principles that I'm going to talk about? And the good thing is that the East Africa Court of Justice, ECOWAS Court of Justice, and COMESA Court of Justice, they have made very important judicial decisions that you should go, look at them, read them, compare them with other regions, and as you prepare for this market, because as lawyers we are going to have new clients, and of course we have financial interest in the market. If you look at one of my papers on the role of lawyers beyond just representing clients, and the role of lawyers as people who push for advocacy and also as entrepreneurs, you will understand that this is something that we should pay attention, because it's creating a market for us, and we're going to benefit from this. So this is just one of the issues that we're talking about, the political economy of negotiations, the lack of political willingness, and how Nigeria navigated domestic interests and its obligations under the AfCFTA to be able to sign the AfCFTA agreement. So these are some of the challenges that arose during the negotiation process. The issue of sovereignty. Unlike the European Union, where the European Court of Justice played a key role in its supranationalism by making decisions that indicated that the EU treaty has a direct legal effect in the EU. In our case, most of our courts, like in COMESA, there's an article in the COMESA treaty that requires that organizational businesses have to ensure that they make use of domestic remedies. And that has always been a challenge before they go to the regional courts. And then the issue of inequality, tariff revenues, the complexity that arising from regional economic communities, and also lobbying. Those are the key challenges that we're going to look at. And as lawyers, you can be on both sides. You can be the business side, you can be representing your government or your own interests. Your clients vary from one to another. So that is exactly a summary of the first issue on historical foundations of the AfCFTA. It was supposed to be 1 hour. I've summarized it in 30 minutes, so we can have 10 minutes for discussion on any issues before we move to the objectives and the core principles. Any question, any statement?
You mentioned like one of the the regional integration challenges is limited private sector involvement. Can you elaborate on that? And also, what are the key challenges that you are facing in terms of implementing the AfCFTA? And also, what are the key challenges that you are facing in terms of implementing the AfCFTA? And also, what are the key challenges that you are facing in terms of implementing the AfCFTA?
One of the regional integration challenges is limited private sector involvement. And my question now is with regard to how do you balance the need to involve private sector with the fact that some of them would be trying to influence policy so that it benefits them, or they create some sort of a cartel system. How do you balance that? Because I've seen that, especially in Kenya, and you find that they come up with policies that lock out other competitors or investors.
Yeah, so that's a very important question. Thank you for raising that. At the end of the day, this integration effort is supposed to enhance trade. And who trades? The business community. And therefore, we have to create a conducive environment for them by removing, that's why we are removing both the tariff and non-tariff barriers to enable them to enter, expand, create continental value chains or regional value chains that are even able to compete in international markets. And therefore, their needs, whether they're contesting or supporting, have to be taken into account and then balanced. So it's not, I always say it's not about just the government needs this, the laws are rigid, we must do this. We are not fighting the business community. We are creating a conducive environment for the business community to be able to do that. So when they raise the issue, and public participation is a constitutional right in most of the constitutions, you have to listen to them. Even if you're making laws on children, you have to literally allow them to participate so that you understand their needs. So if traders can tell us, I was trying to move my goods from here to Morocco, and this is what I experienced along the way, we have to take into account that. So that is the role of the public participation and stakeholder engagement. So we have to bring everybody on board. Consumers have to also be brought on board. Judges have to be brought on board, and everybody that is important into this project that we are working on. So let's look at the core objectives, as the other experts will go into detail on every protocol. So I don't want to go into detail and take their work, and then they will not have much to say at that time. So those are the challenges that the negotiation of the AfCFTA first, but now we have the AfCFTA agreement, and I think we're excited to have an African-based instrument that will be able to create a continental market. The market is big. We have young people, we have youth, entrepreneurs that are trying to come up with novel products, especially in the digital market. I focus on youth and children in the content creation market as well, and how we can be able to make sure that Africa plays a very important role, and we are able to address the issues of poverty on our continent and also create job opportunities. So the objectives of the AfCFTA are well stated under Article 3. It's a culmination of all the progress we've talked about from colonialism to where we are now. And it aims to create a single market that ensures free movement of people, free movement of services. And this is where we have some countries providing visa free, so that people are able to move while other countries are very reluctant to do so. Most importantly, to boost intra-Africa trade, trading among ourselves. African countries are known to have this attachment to their former colonizers, trading more with them. That is not a problem, because they need some of the things we have that they don't have. But sometimes it doesn't make sense for a country like Nigeria to produce oil to go and be refined somewhere else and come back as an end product that is extremely expensive. We want to boost industrialization to ensure that our national champions or small businesses are able to regionalize, establish regional value chains. We see Kenyan Safaricom now operating in Ethiopia and other countries. It should be easy for me when I'm in Uganda or Tanzania or Nigeria to just use my M-Pesa to do so, to trade. We want to also reduce trade barriers by eliminating both tariff and non-tariff barriers to trade. Most importantly is to enhance competitiveness at the continental level, at the global level, And one of the issues, if you can read my most recent paper on public interest consideration in the South African trade and markets, whereby when we are looking at competitiveness, market competitiveness, what are the particularities of African markets? For example, in South Africa, there's an issue of empowerment of the Black people, which is very important in their constitution, their regulation. If you are trading in South Africa, you have to ensure that you are supporting historically disadvantaged persons that were racially discriminated in the apartheid regime. And it happened in many ways, including white people were able to access credit to establish their companies. White people, Black people were not. And as markets develop, you see the Black people not able to enter into the market and compete. So those are some peculiarities. We want to understand what is the peculiarities of Malawi, Zambia, Liberia, those countries, and bring all the discussion on the table. And of course, sustainability, environmental protection, promotion of social economic rights. Those rights are like rights to water, sanitation, right to food, socioeconomic rights, gender equality as well. Those are some of the key objectives of the AfCFTA. And those are the general objectives. Article 4 provides a number of specific objectives that will be able to enable us achieve the general objectives. So for example, if we want to boost industrialization and we also want to enhance our competitiveness, then cooperation on investment, intellectual property rights, and competition policy becomes very important. Cooperation on custom matters and the implementation of the trade facilitation measures. Progressive elimination of tariff and non-tariff barriers, and progressive liberalization of trade in services, and also establishing institutional framework at national, regional, and the continental level. And most important is the issue of dispute resolution, and Professor Simo is here to talk about this, whereby most African countries believe in consensus building instead of rule-based institutions. So, and of course, with the limitations, especially in our treaties that require private stakeholders to exhaust local remedies before they seek remedies at our regional courts, it becomes very important for them to get justice or even institute legal proceedings at the regional courts. So the AfCFTA is also based on a number of core principles, Article 5 of the AfCFTA. Kofi is going to discuss in detail the module on scope, legal architecture, and interaction. That's why I'm just trying to provide an overview. So the regional economic communities are building blocks of the AfCFTA market. So whatever progress they have done, it's what will inform how the continental market works. So we are not removing them, we are complementing them. And that is why we are going to learn from them. They are really key stakeholders. The principle of variable geometry, okay, let me just. So this is a list of them. So on the next slides, we look at each of them. So we've talked about regional economic communities as building blocks. So just as Leah has said on the issue of classification, least developed countries and so on, we are not on the same level of development. And therefore, the principle of variable geometry allows the countries to meet their obligation in accordance to their capabilities. So we have differing readiness and capacities. We want to ensure there's progress without delaying faster moving countries. So we are able to accommodate the diverse sizes. So this will talk about how it has really happened in practice. So because of that differences in our development, in markets, some countries got the independence a little bit late, investment, logistics, and so on. The principle of flexibility or differential treatment is also a core principle of the AfCFTA and generally of regional integration efforts in Africa. So the main justification of this is to support inclusive and equitable integration. Even in your family, our children's capabilities vary, and then you have to support them differently, but still you have the main objective as a family, and that is exactly what we are doing at the AfCFTA. So this simply means that, for example, when I was coming here and the Tanzania-Zambia train, which allows to Tanzania to connect with Zambia, this is some of the things you're talking about, like supporting each other, creating this institutional framework in which all of us can work. So substantial liberalization also still speaks to the two principles we've talked about, ensuring that at least 90% of tariffs lines to be liberalized, but depending on the country's status, either step by step. And this still goes back to the Monrovia and Casablanca argument when establishing the Organization of African Unity of whether we were supposed to go slow until we have this continental market, or we should just leapfrog. So these are some of the issues, because some countries will argue that their liberalization has to be substantial because they don't just want to open their markets to foreign participants that will lead to dumping of goods, and also when there's a dumping of goods in a market, it also inhibits local industries. So it means that we have to also look at the industrial policies and also how to balance all this. Another principle is the principle of national treatment, whereby some member states would want to treat domestic producers favorably compared to other producers, and it applies to goods that have entered the market. And I think when I'll be talking about the case study of national treatment, I'd really be honored if the judges from the COMESA Court of Justice would give us an overview of how they've been able to deal with some of the cases that have been brought at the COMESA Court of Justice in relation to national treatment. So that if a client comes to you, a business, and says that I was importing my goods to Malawi, and the domestic producers are not, taxes are not imposed on the local producers, the goods are the same, but these are the taxes that are imposed on us, and they want you to give legal advice, or they want you to institute legal proceedings. What exactly will you be looking into? The most favored national treatment, which makes an assumption that all the member states are equal, but that is in theory. In practice, we are not equal. But irrespective of that, no member should receive better treatment than another. So if the goods are the same, and let's say the goods are coming from Sao Tome, the other part of West Africa, and the same good is coming from Ghana, and they're being traded in Tanzania, you are not supposed to treat them differently. And if you're treating them differently, even in relation to domestic producers, you must give justification in accordance to the treaty. Reciprocity, it's all about how we treat each other. So it enforces mutual benefit under the agreement. It enhances exchange of trade concessions mutually. So treat me the way I treat you. Treat me well. I remember there's a time when Kenya and Uganda, I think if you follow social media so much, the time when our chicks died on the border. Like, you see, those are the things we are talking about, the practicability of all these things. If I'm allowing your goods to come here, allow my goods to also enter into your market. So it's involuntary, depends with your willingness, but it's also in good faith to just treat each other. Transparency and information disclosure is also one of the core principles of the AfCFTA. And Article 5, the regulations must be publicly available for the private sector to access. They must be clear, and they should promote compliance and just reduce the risk of arbitrary trade measure. I think this one is extremely clear. So Matthias sent us a list of all the trade agreements that are related to the AfCFTA and the African integration process. So those laws should be very clear. And I think it's very important for the AfCFTA Secretariat to make sure that these rules and regulations are not only on their website, but we also have a summary of them for our businesses to understand these issues in a more clear way. The preservation of the principle of access, this one is also found in the AfCFTA competition protocol, that we are not replacing the general economic community, but we are making sure that whatever levels of integration are processed, they are at. COMESA is really doing extremely well. They are not reversed. And the higher standards that have been achieved under these regional economic communities will inform other regional economic communities that are still young, because once we do that, then we move forward, just as Leo has seen, as a unit when we are competing against global firms. So this goes into dispute resolution. I think it's one of the issues we are going to discuss in detail. It's about consensus-based decision making. So what it does is that it promotes legitimacy. Although African countries, because regional integration across the globe was driven by EU, and when you look, if you read my paper on supranational or confederate institution design, where I'm looking at how do African countries decide whether to have a supranational law or not a supranational law. SADC, they don't have, you look at the cooperation regime, it's not supranational, they provide a cooperation framework. When you look at Asian countries, for them, their norms is about external interference. So most of their institutional framework are usually based on consensus-based. In Africa, it's the opposite. We establish supranational institutions, but in practice, we employ consensus-based decision-making. So it's like, so it will depend on the political willingness of the country. So that's exactly what is now incorporated in the AfCFTA, the issue of consensus-based decision-making. So we go to case examples so that at least we make it lively. So these are some of the cases, one of the cases under the East African Treaty that was handled by the East African Court of Justice, the British American Tobacco versus the Attorney General of Uganda. So in this case, Uganda imposed a higher excise duty on imported cigarettes from Kenya than on locally manufactured cigarettes. And the principle that it was violating was the principle of national treatment, that once you're part of this agreement, you are not supposed to treat other producers differently. It doesn't say that you cannot have a domestic regulation on this, but if you were to do that, as the judges will tell us in a few, then you have to justify that. And if there's no justification, that just means you are treating other producers unfavorably. So the East African Court of Justice held that the tax differentiation was based on the origin of goods and was a violation of the EAC Treaty and the Common Market Protocol. So they must be treated as favorably like domestic market. And then we had also another case at the COMESA level, Polana versus Mauritius, and that's why we are saying under the principle of affairs that whichever development that will have been done by regional economic communities is going to inform whatever we are going to do at the AfCFTA. So we must, and I always say it's in my qualitative and quantitative work, is to go to the African institutions, to the practitioners, ask them, because at the end of the day we come up with laws, it's all theoretical, but the people who enforce are the people who are based in these institutions, and find out what are the cases they have handled, how have they been able to interpret these cases. Most of the time we know what US is doing, what the EU is doing, and we don't pay attention to what our courts are doing. And there's a lot of jurisprudence from the African regional courts on these issues that we need to really follow. Even on the issue of domestication of African treaties, our courts have made decisions that have provided direct effect of these treaties, irrespective of whether the countries have domesticated them or not. So this was another issue which I think one of our judges from the COMESA Court of Justice might provide us with the legal test that they used. And therefore, as they speak about that, I want you to read this. And it's about, maybe I can read it out. There's a Ugandan company that has lawfully exported processed edible oil into Kenyan market. But then upon entry into the Kenyan market, domestic oil producers benefit from zero excise duty. And the imported Ugandan oil is subjected to one, a higher excise tax, additional inspection and certification requirements, and delayed market access. So Kenya argues that the tax is an internal tax measure, not a tariff. And then the policy on additional, the word there is additional, inspection and certification requirements seeks to protect public health and local industry. And the measure applies equally to imports as a category. But then, the Ugandan exporter contends that the measure discriminates against products on the basis of origin, as domestic products receive more favorable treatment than it violates the national treatment obligations. So as the Ugandan exporters approached you for legal advice, kindly identify the legal issues for the determination and advise accordingly. And at the back of your mind, you should know that the AfCFTA, trading under the AfCFTA has also commenced. So as we think about this, I would like to welcome one of the judges to tell us how they've been able to handle some of these cases.
I don't sit on the COMESA court, so I'm not going to profess to be an expert. But if this matter came before me, and considering what you've said, I think first of all I'd look at reciprocity, which is what you talked about. You spoke about reciprocity under the African Continental Free Trade Agreement. So is there a reciprocity agreement between Kenya and Uganda? And if it's there, then I would think that the treatment that's been given to the imported Ugandan oil is less favorable than the treatment being given to the Kenyan oil. So I think that's a test I would look at, because if you're going to impose the taxes which are not imposing on your local products, and you have this reciprocity agreement, then obviously you are not treating those goods the same. I may be wrong, right? I don't know. Thank you.
Yeah, I think she has raised another gimmick on the aspect of balanced reciprocity or economic reciprocity. Vienna Convention on consular matters and foreign relations of 1963 and 1961. They also have an aspect of the economic reciprocity, especially when to diplomatic relations. I don't know how is that also coming in the arrangement that we're talking about.
Thank you. Oh, I'm not the judge, but I wish I was. So, if this case came before me, right, are we talking about first, which agreements are we talking about? That's what the first thing you have to determine. Are we talking about the East Economic Community Agreement? Are we talking about the AfCFTA? Now, if it's about the AfCFTA, we have to look at the agreement which is being cited by the complainant, the basis for their complaint. If they're saying it's a protocol on trading goods, then you look at the rules that apply to the product, which is at issue. And in this case, we have a clear case of national treatment here, violation. Now, what do the rules of national treatment provide in the AfCFTA protocol on trading goods? So if, from my recollection, it says that you must not use internal measures so as to provide protection to your domestically produced goods. So in this case, if the measure is affording any protection to any domestic product, then it could be a violation of national treatment. So it depends on to what extent that measure actually give protection or afford any type of advantage to locally manufactured products.
And that, before I go to that, that was the first thing I wanted us to identify. Which rule applies? Kenya, Uganda is a member of EAC. Kenya, Uganda is a member of COMESA. Kenya and Uganda are members of the AfCFTA. And that's what we're talking about, the complicity of all these rules at the national, regional, whatever level. So as a lawyer, before you even decide whether to institute these proceedings, which rules apply? Where are you going to institute? What are you literally advising them against? So that means you have to understand not just the AfCFTA, you have to understand the EAC, you have to understand the COMESA, you have to understand the ECOWAS. So that work is up to you. Yes, Leah?
Thank you. Assuming you've already identified the rules, I would also now bring in the aspect of health as an exception. Under the mother of all international trade, the WTO, that's where it begins, the exceptions where you can now impose certain limitations in terms of taxes and all that. So could the issue of public health be one that to be considered, that perhaps the oil that is coming in has some elements that may not necessarily be suitable for the public general health? Thank you.
Leah is acting for the government in this case. And that's why I put the qualifying word additional inspection and certification requirements. And therefore we go back to the principle of good faith. Is it justifiable, or is it just one way of delaying the entry of Ugandan edible oils, because Kenya is also producing edible oils and selling, and therefore we want to protect our own companies. So it depends with who are you acting for. Any other observation? This is how we are preparing ourselves.
For me, it's just to say the obvious. The obvious is that you then have to look at the case law and try and find a way through. After you've identified, of course, the protocols that apply and all that, and then apply the case law to the facts and see what you can get out with.
In that case, is there anyone who has gone through the Polana versus Mauritius case at the COMESA Court of Justice? Okay, I'll not give you the details. As I stated, you have to do this. Because this was a very important case on the direct effects of the COMESA Treaty in a country that has not domesticated the COMESA Treaty. And for those like Eswatini, is one of the countries which, when it came to domestication of the COMESA Treaty, because I've been doing this research and interviewing a lot of officials on this, on how regional economic communities have been able to navigate the issue of domestication of domestication of treaties, whereby the gatekeepers, and mostly in the African setup, judges can act as gatekeepers, because if they refuse to make a favorable decision to the direct effect of a treaty, it just ends there. And most of the decisions are usually binding. And also, in this legislative process, you start from the national level, you involve all the stakeholders, the law has to go through the Attorney General and all these people that are involved there. So I was tracing all this legislative process to see. So for example, in the case of Swatini, I think it's under Article 206 or 203, or something of the treaty, they have these provisions that, that tries to circumvent the political process, whereby they indicate that there are some regulations and laws that can be enforced directly without really having to go through the domestication. And the Attorney General and the Commission authorities were able to argue that the COMESA competition regulation was one of them. So that is how the COMESA competition regulations now have a direct effect in Eswatini, despite Eswatini as a country not domesticating the COMESA treaty. So these are just some of the issues that we are trying to navigate. And I always say, in this digital era where information is so democratized, you can use generative AI, you can use ChatGPT, not just ask it what you will eat, but to ask it to give you some of the cases that COMESA Court of Justice has done, ECOWAS Court of Justice has done, some of the contestations, and you'll get this information. It's all about how you prompt. So it's still, this is a competitive market as legal practitioners. Whoever will do the research well will be able to compete for these markets and get clients. So these are just some of the, every principle has its own legal test on how to determine. So you really have to really understand. For example, in this case of national treatment, the courts have been able to look at first the origin of the goods. Is it being discarded because of its originating? Are the goods similar? And then is the treatment justifiable? So for example, as Leah argues, there's an additional inspection and certification requirements. Was it justifiable for protection of public health and local industry, or it was not? So now we go beyond now the legal requirements and look at the circumstances of the case. And we can easily infer whether it's justifiable for that additional certification to be done or not. So whether you're on the government side, the business community has come to you, or you just want to drive policy, like some of us who are engaged in legal and policy work, you really have to really understand. So these are some of the key questions that we should be asking ourselves, especially for judges in the House. How do we test less favorable treatment? And kindly have a look at the two cases at the COMESA Court of Justice and the East African Court of Justice on how they were able to say that this is a less favorable treatment, because lawyers will come with their own defenses and you have to make a decision on this. How do you test this is a less favorable treatment? And then, of course, the AfCFTA has to work hand in hand with national institutions, the domestic courts. There are always rules that can inhibit the enforcement of the AfCFTA decisions. We don't have an AfCFTA court. I don't think we have one. But I think in most of the protocols, because competition is what I'm good at, we have the competition tribunal. But at the end of the day, making a decision at the higher court and enforceability at the domestic level is another thing altogether. So they really have to work hand in hand. For the legal practitioners, kindly look at all those core principles under Article 5, be able to understand which laws apply. at the regional level, at the national level, the legitimate policy objectives, just as Leah has said, the justification of all that is not like it's an outright prohibition for a country to treat another one differently. It's just, is it justifiable to treat this differently? Is it that you're just protecting your market, industrial policy? But also, it's also justifiable to protect your domestic market. So all these things is about how you're gonna balance. For private practitioners, how, if the Ugandan farm came to you, how can you effectively document this discriminatory treatment? And what remedies are available? You know, I live in Germany and I'm very good at time. So this is the end. You're telling me I have a few minutes, but I'm done.
Since it's here, I'll start. So there are two things. First, maybe this one will go to the judges. Since they are judges of national courts, I have seen in some cases which are very technical that national judges are very rigid towards national laws that are maybe insufficient, and they are not susceptible to maybe referring to regional courts, or maybe the cases decided in other jurisdictions. So my question to them, and you call them gatekeepers, and I want to align myself with that. Why would the system then be rigid on just focusing on, yes, it's admissible, it's not admissible, and how do you now try to balance that and enriching the jurisprudence of your nation? Then another question. When we were thinking about that question, I was just thinking from the perspective of the state, and I was looking at the general exceptions and the security exceptions, and how we've had a broad interpretation of that, and how states invoked that very much. So how, my question to you and the floor is, we have these exceptions. Are some of them necessary, and are they counterproductive? Because if at the end of the day I say I'm protecting, say, public moral, and public moral is it's different for different nations, and it's say a movie, you can't do anything about it because it's the country that decides what's public moral for them. So are they necessary, some of them?
So judges, you've had your question. So I think you addressed your hand, so you'll be able to answer it as you ask your question.
Somebody has another question. Here's a question also.
Thank you so much for the wonderful presentation. I think my question is similar to what my colleague just asked, though it raises a different dimension. I know you highlighted the aspect of enforcement, I think, which is very, very important. I know that at a COMESA level, once a decision has been issued by the COMESA Court of Justice, there's that requirement that the decision is registered in the member state. So I wanted to find out at the African Continental Free Trade angle, what would be the ideal way of enforcement of decisions at a continental level? Because, you know, what is also as important is that even as we come up with these agreements, enforcement must be very clear to all the stakeholders, because that in itself obviously gives confidence to these institutions that we are setting up. So could you just kindly shed more light on the ideal way of enforcement of decisions at continental level? Thank you.
Okay, so we'll have him, and then we'll have Regis answer your question on how it's done at the AfCFTA.
Thank you. I want to solicit your opinion. I've looked at the core principles that you talked about, and I'm thinking about the underlying principles that may have informed the formulation of the core principles. Now, my question to you is, do you think countries generally want to help each other in the economic progress journey? Or to put it differently, do you think rich countries want poor countries to become rich like them?
Oh, indeed, it's an opinion. So theoretically, we do expect that countries should be able to trade with each other, but it's interest-driven. Of course, it's interest-driven, so we want to do more than the other, but how can we reach the consensus to support each other? And that is why Nigeria delayed in signing the agreement, because it was just afraid of the dumping of goods, opening its borders to others. But still, Nigeria companies are trading in a lot of African companies, like Dangote company has operations in a lot of companies. So it still narrows down to political willingness. And we hope that in the spirit of Ubuntu and Pan-Africanism, we should be able to do this. And there are questions for you. Okay.
I wanted to try and answer this one.
Okay.
Well, first comment, just before I get to his, is that you spoke about AI or chat. What I've learned with AI is that it does not have a no answer. It will always give you an answer. And that is why they now talk about hallucinating. Yeah. So if you are not careful and you don't check, even my own jurisdiction, it will give a Lamini against so-and-so a case that's not there. So you just have to try and very careful when it comes to that. It's, still new. I think his question for me, I would just say that if there's scarcity of developed jurisdiction, of what our jurisdiction know about the issues that are there, we then, of course, a lot of times judges will rely more on what counsel actually brings to court, especially when it comes to those areas that are still new. Now, if that is weak in itself, and you are now looking at you start looking at if these facts can actually be decided on this case. So you look at the preliminary issues. You want to deal with those preliminary issues because you also have piles and piles. So you'll always find a way, not like AI, but at least whichever way you are actually going to find will rest the case for that moment. It can be seen later. So.
Okay. So lawyers, you have to prepare. We had Regis to answer on the issue of enforcement.
So the example that you gave, the scenario with COMESA, and then let's say you're a member of the East African, and then at the same time, AfCFTA rules apply. Is there some sort of guideline where there's some sort of clarity as to which of the laws should apply? Like, let's say when it's X, Y, and Z, it should be COMESA or it should be AfCFTA. Because then if there's a party that belongs to all three of these, which of the rules of these distinct institutions would apply? I know that is by a case-by-case basis, perhaps, but there should be some sort of guideline that says, for this, go to that. And so far, I'm not quite clear on that. Yeah.
This discussion really makes this training very important because we love these issues. And because the other lectures are going to discuss each and every protocol, we can ask them those questions in the next session so that we can go and have lunch.